attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first Lawcast in a series about U.S. investments in foreign businesses and foreign companies trading in the U.S. public markets. In June 2016, the Indian government announced new rules allowing for foreign direct investments into Indian-owned and domiciled companies. The new rules continue a trend in laws supporting India as an open world economy. A large portion of the U.S. public marketplace is actually the trading of securities of foreign-owned or held businesses. Foreign businesses may register and trade directly on U.S. public markets as foreign private issuers, that's what they're called, or they may operate as a partial or wholly owned subsidiary of a U.S. parent company that in turn quotes and trades on either the OTC markets or a U.S. exchange. As a precursor, it is important to provide a brief overview of foreign private issuers under the U.S. securities laws. Both the Securities Act of 1933 and the Securities Exchange Act of 1934 contain definitions of a foreign private issuer. Generally, if a company does not meet the definition of a foreign private issuer, it is subject to the same registration and same reporting requirements as any U.S. company. The determination of foreign private issuer status is not just dependent on the country of domicile, though a U.S. domiciled company can never qualify regardless of the location of its operations, assets, management, and subsidiaries. There are generally two tests of qualification as a foreign private issuer, and they are the relative degree of U.S. share ownership and the level of U.S. business contacts. As with many securities law definitions, the overall definition of foreign private issuer starts with an all-encompassing any foreign issuer and then carves out exceptions from there. In particular, a foreign private issuer is any foreign issuer except one that meets the following as of the last day of its second fiscal quarter. That is, it is a foreign government. It couldn't qualify if it's a foreign government. Or one in which more than 50% of its voting securities are directly or indirectly held by U.S. residents, and any of the following. The majority of the executive officers or directors are U.S. citizens or residents. More than 50% of the assets are in the U.S., or the principal business is in the U.S. Principal business location is determined by considering the company's principal business segments or operations, its board and shareholder meetings, its headquarters, and the location of its most influential key executives. That is, this is the way the test works. If fewer than half of a foreign company's shareholders are located in the U.S., it qualifies as a foreign private issuer. If more than 50% of its record shareholders are in the U.S., the company must further consider the location of its officers, directors, assets, and business operations. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.